Two documents, one courtroom, $1 billion question. Where does creativity end and infringement begin? The record labels call it wholesale theft. Alleging Suno AI has taken their most valuable assets, music, soul, and culture, to fuel its algorithm. Suno's response: a masterclass in legal deflection, painting itself as a revolutionary, not a criminal. Today we're diving straight into the heart of the Suno AI case, dissecting the plaintiff's complaint and the defendant's answer. Hello and welcome back to AI Serendipity, where tradition meets innovation and we always ask the hard questions. I am Santiago Martin Caravaca, an Italian Spanish dual qualified tech and IP lawyer, a technologist by curiosity and your guide through the twists and turns of the Suno AI case. In today's episode, we are diving into the structural anatomy of two essential litigation documents, the complaint and the answer. These filings form the backbone of any legal dispute. By understanding how these documents are structured, we can better grasp the legal strategies at play in this high-profile case. Let's break down some key legal terms from the complaint and answer, placing them in the broader context of American litigation and intellectual property law. As you know, every lawsuit begins with the complaint, the formal document where the plaintiffs lay out their grievances. It's their opportunity to present the facts, allege wrongdoing, and articulate the legal violations they claim have occurred. Structurally, the complaint is organized as follows. Caption: this section identifies the parties involved, the court, and the case number. Nature of the action: this is a broad introduction to the case, summarizing the plaintiff's grievances and the overarching legal issues. The parties: here the plaintiffs provide detailed descriptions of who they are and their role in the case, followed by information about the defendants. Jurisdiction and venue: this explains why the court has the authority to hear the case and why this specific location is appropriate for the lawsuit. Factual background: often the heart of the complaint, this section narrates the key events and facts leading to the dispute, laying the groundwork for the legal claims. Claims for relief: technically, a claim for relief is a particular set of facts that one party puts forth in a pleading in court to establish that they have a right to recover against a defendant. Think of it as the plaintiff saying, "This is what we believe you did wrong, and here's what we are asking the court to do about it." It's a chance to set the terms of the battle, defining the scope of the legal dispute. Essentially, it is the blueprint for the case. In this case, the complaint contains two causes of action. First cause of action: direct copyright infringement of post-1972 sound recordings. And the second cause of action: direct copyright infringement of pre-1972 sounds recordings. The prayer for relief: this section outlines the remedies the plaintiffs are seeking, including damages, injunctions, and other forms of relief. The jury demand: if the plaintiffs wish to have a jury decide the case, they explicitly state it here. On the other hand, noticeably, this complaint does not include a preliminary statement diving directly into the facts and legal claims. Now we are going to see together the overview of the answer. The answer is the defendant's formal response to the allegations in the complaint. It is their opportunity to counter the plaintiff's narrative, deny or admit specific claims, and assert legal defenses. The structure of the answer mirrors that of the complaint but includes some distinct elements. In this case, Suno uses a preliminary statement. The preliminary statement provides an overarching narrative summarizing the defendant's position and setting the stage for the legal arguments and to frame the plaintiff's claim as unfounded and driven in this case by anti-competitive motives. Responses to specific allegations. In this section, the defendant addresses each numbered paragraph of the complaint, either admitting, denying, or stating that they lack sufficient information to respond. The affirmative defenses. These are legal defenses that, even if the allegations are true, argue why the claims should fail. Examples include fair use or innocent infringement. This is where the defendant outlines what they seek from the court, such as dismissal of the case or recovery of attorney's fees. Finally, with regards to claims for reliefs, in Suno's answer, we can see that starting with paragraph 83, Suno systematically addresses the claims for relief section of the complaint, responding to each paragraph in order. Today, we have dissected the structural anatomy of two key litigation documents, the complaint and the answer. If this episode sparked your curiosity or left you with questions, don't just listen, subscribe. Join us here at AI Serendipity. In our next episode, we'll dive deep into the request for relief, exploring the first cause of action, the post-1972 copyright infringement, and the second cause of action, pre-1972 recordings. Until then, keep questioning, keep asking the hard questions. And remember, innovation is inevitable, but how we embrace it defines who we are. See you next time.